Thanks for joining us. So this is the second Know Your Worth Art and Design lecture series. We have four, so we're excited to have our lawyer here. So this is Joshua Lida. Um, as creatives, we constantly question how much does our output cost, right? So what it is that we're creating, and how much is that worth? So this is why we created this Know Your Work lecture series and workshop, which helps you guys and also us as artists and designers on how to navigate this kind of business oriented side when it comes to our creative, endeavors. So with this particular talk, we're going to be learning the basics of the legal system, some copyright issues that a lot of us might have questions about. I know that I'm constantly giving assignments within my class that deal with doing some research on art history and also artists that are contemporary and presenting a work that might have been inspired by that. So I question that all the time. So thank you, Joshua, for being here and helping us navigate those kinds of questions. And he's also going to help us understand the practicalities of this thing called law. A few things that I want to say, right? So we have some upcoming events that are happening. So next week is the senior exhibition. We have 5 ladies. The show is called Eminon, and that opens Wednesday, and it's going to be virtual from 5 to 7 p.m. So make sure that you look through your emails so that you guys can participate and see what kind of work comes out of our seniors. We also have a juried exhibition which opens March 17th. The juror for that is Guy Harvey, which is a really, 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 really big deal. So we're super excited for that. And he's also going to give a talk that'll be our third Know Your Worth. And that's, again, is going to happen March 17th from 5 to 7. And then our last lecture series talk is with C. Adams, who is very well known in the hip hop community. And he's also here in Fort Lauderdale. And that's going to happen April 7th, and it's at noon. I didn't introduce myself. So for those that don't know me, my name is Candy Lopez Moreno. I am a faculty member here for the Art and Design program. We're part of the Department of Communications, Media, and the Arts under the Halmos College of Arts and Sciences. With us, we also have Dr. Miriam Ahmed. She's waving, who is the professor in the graphic design realm or concentration here in the Art and Design program. And we also have our chair for the Department of Communications, Media, and the Arts, Dr. Shanti Bruce, who's also waving. And we have Josh. So I am spinning it off to you. So whenever you're ready to educate us on law, I am here and I'm taking notes.
All right. Well, hi, everybody. My name is Josh Lida, as Candy so eloquently put a little bit earlier. Thank you to Candy, Shanti, and Miriam for having me, and thank you for all for being here today. So before we get into copyrights and the law and all the boring stuff, let's tell you a little bit about me. I'm one of the founding partners of Twig Trading Tribunal, PLLC. We are a law firm here in Fort Lauderdale, Florida. We practice in appellate work, which is like the higher level of courts after the lower courts rule, real estate, property, trust, and then I'm the director of the art and business law section. Yes, art law is a thing. Yes, I do practice it. And part of what we're talking about today, we'll go into that. I'm a local Florida boy. I grew up in Plantation. I went to UCF, and then I went to Nova for law school. So I know your campus very well. I used to play basketball in those basketball courts, used to work out there, met my fiance there. So I have a lot of affection for NSU. When it comes to art, I've always been involved in creative endeavors. I play guitar. My friends and I used to make movies, and my grandfather used to sculpt and like make jewelry. So I was always into the creative side of things. And more recently, through the career path that I've taken, I've been able to help more artists along the way. So whether it's copyright issues, trademark issues, contracts, there's a lot of things that go into the business side of things that are very important. And I'm lucky enough to be able to guide people through that process. So that's part of what we're going to talk about today. It's a Know Your Worth series. I think it's extremely important for artists to know that your work has value. And it's not just the physical object, which is what we're going to talk about today. There are intangible things that you produce that has value as well. So being able to understand the different components of what you bring to the table and knowing that in advance will hopefully allow you to better sort of orient yourself as you move forward throughout your career. Fair use also, we're going to get into a little bit later, as far as taking bits and pieces from prior works. I'm sure collage artists, if there are any on here today, are very curious about taking, I see Candy raise your hand, taking actual images and repurposing them. Obviously, a lot of famous artists have done it. I mean, Warhol's highest grossing sales piece of all time is a photo of a car crash, right? I mean, and it's actually called that. So it can get pretty complicated, and we're going to try to spin out the legalese, and I'm going to try to make it as plain as possible. So with all that being said, we can get started. I don't know. Let me screen share. I don't know if you guys received the outline. Can you see my screen, or is it just the outline?
We can see the outline. The screen is like black on the back.
Okay, beautiful. So obviously, this is not legal advice. An attorney is an attorney is an attorney. So I got to put the little legalese things on there. This is just, generally speaking, it's just from an educational perspective. One of the things we're about to talk about is it's really impossible for attorneys to say definitively what is or is not okay and how things are going to turn out. We can't really predict the future because reasonable people can disagree, and a lot of times unreasonable people can be involved in litigation. So here's going to be the introduction to the legal system. I want to come at it from a practical point of view for you guys. It doesn't necessarily work as smoothly as you may think. What do I mean by that? So if we're dealing with a lawsuit or maybe a contract negotiation, we would assume it's standardized because there are laws and there are regulations and there are court systems, and it's been around for a long time. So we would think that, okay, a case is pretty clear cut. Both sides are going to be honest. Both sides are going to want to resolve the situation. This will be over, no question. I'm in the right. It doesn't work like that. First and foremost, the court system employs people. They are human beings. Human beings make mistakes. Human beings get overwhelmed with family, with work, with the pandemic. So that in and of itself slows down the court process in most cases. And then on top of that, you're relying on third parties. So maybe you're waiting on the judge to set a date for a hearing, or you're waiting for your opposing counsel to send you a document for you to review that you need for the case. Any number of things can sort of slow down the process. And so you're looking at a process, if you file a lawsuit, I mean, you're looking at 6 months to a year, usually at a minimum, unless it's so clearly obvious that it should settle straight away. And even then, a lot of times people don't want to settle. They don't want to look like they lost or they were wrong. So it's important to realize that, let's say down the road, you're a practicing artist, someone screws you out of some money and you want to go after them. Oh, well, it's clear cut. I'm going to win. It'll be quick. Not a big deal. It may not go so smoothly. Maybe they have evidence. Maybe they have text messages. Maybe they have, your business practices in the past. It's a little unclear how things will play out. So moving on to the next section, what I was alluding to, just because you think your work does not infringe doesn't mean a jury or a judge will agree with you. So it's just like art, right? We can all look at Duchamp's The Fountain and someone could say, oh, it's a urinal. And another person could say it's a brilliant piece of art, right? And both opinions are correct. That's one of the beautiful things about art. That's one of the negatives about the law, is that even if something is to most people clearly, on one side of the issue, the jury might not agree with you. The judge might not agree with you. They might view it completely differently. They are not an artist. They don't necessarily understand. You can spend the whole trial trying to educate them on the thought process behind the work or how it's accepted within the art community to take certain items, and they might think you're wrong and you might lose. And then you might be liable for lots of money. You also might win. The point is not to scare anyone here. The point is just to bring you down to earth when it comes to the practicality of things. You can have the best lawyer in the world with the best case and still lose. So, what I always like to tell people when I give a spiel to potential clients is keep in the back of your mind, what's the worst case scenario? What's the best case scenario? Obviously, you want the best case, but you should always keep in mind, what if I go to trial and lose? What if I play hardball with this negotiation and the deal that I'm working on that I really want drops out because I pushed too hard? if you are speaking with a lawyer, the lawyer should tell you both, and then should say to you, how do you want to proceed? And then me as a lawyer, I'll tell you different strategies to accomplish it and different points of view. But ultimately, you need to make the decision. So you need to just be aware that it's not going to be clear cut, and you need to listen and you need to think about it clearly. Pick and choose your battles wisely. So an attorney, even if you offer a lower rate or a reduced rate, or you're using an organization, if the case is dragging on for a year to 2 years to 3 years, it's going to get expensive. In addition to lawyers' fees, you're going to have maybe travel time for you in the car. Maybe you'll be deposed, which is a day off of work or a day off of painting. Maybe you have to pay for a private investigator. There's any number of things that can add to the cost and the expense. So unless you have an unlimited amount of funds and you're willing to get into lawsuits on a regular basis, like some of the bigger dealers do sometimes, then it's really not cost effective to constantly be litigating. If someone screws you out of $250, you got to sit there and think to yourself, do I really want to take this to court? It costs a couple $100 just to file the lawsuit, and they might not pay your attorney's fees, and you might not ever get the money back. So it's just something to keep in mind. I need to be strategic with what I utilize as the basis for a case. So some of the things to consider when you're thinking about your strategy within the legal side of things. Does it appear that you're in the wrong? I mean, be objective with yourself here. Ask friends, talk to your lawyer. Did I do something wrong here? Does it look like they're clearly wrong? How strong is your case? How strong is their case? Is it even worth the money? How much money is at stake? If it is worth the money, how much is it going to cost to defend? Is it a breach of contract? Is it an IP issue? All these little details build up to a bigger picture for you to think about before you make your decision. But as I stated earlier, ultimately, it's not to scare you. The legal system is messy, but it's essential and it's useful to protect your rights. We're not going to talk about this case today, but there was a major decision regarding the 5 Points graffiti outpost in New York recently under VARA. And the artists sued because the guy wanted to tear down the building and tear down all this beautiful graffiti work that had been there for years. And the artists did win. Now, the work was torn down, but they ultimately recovered a good amount of damages because it had gained so much notoriety and fame. So the legal system is there. It's there to protect you. You have rights. And I encourage you to reach out to a lawyer if you think you have something against you. Generally speaking, when I tell people is if you're a little uncomfortable with a situation and you're not sure where it's going to go, I would talk to a lawyer earlier in the process. When lawyers get involved earlier in the process, oftentimes you can keep the costs lower because they won't have to learn halfway through the case what's going on. They won't have to spend the time sifting through all the documents that you've already gone back and forth with. They can just sit down with you and be with you through the time. So that's just something to think about. And to reiterate, this is partly business advice and partly legal advice, but think of yourself as a business and think of yourself as the CEO of the business. So not everyone has the same viewpoint of success. Jeff Bezos and Elon Musk's and what they're trying to accomplish isn't necessarily what you're trying to accomplish. For many people in the creative field, or, I'm a big craft beer guy in the brewing sector, their success is supporting themselves and being safe and taken care of while doing what they love and making other people healthy. So if that's what you're going for, then your decisions should be geared towards achieving that goal. So like I said, determine what success looks like for you. Develop what you think is the best way to achieve that success and try to stick to that plan. Surround yourself with mentors and professionals, even lawyers, accountants, business advisors, financial advisors, anyone who can give you advice along the way so that you're constantly learning and establishing yourself in a manner that will allow you to continue for many years, where you're not going to come into a crisis every 6 months if sales do a downturn. Invest in yourself. Get these practices in early. Establish them early. But be flexible. Don't be afraid to change as you move along. You don't have to develop a plan when you're 22, 23, and stick with it for the rest of your life. Your definition of success can change, just like your art medium can change. Maybe you go from collage to light, to like a Dan Flavin light installation. There's a lot of different things that you can do to adapt as you move along. So just try to keep that in mind as we go throughout this process. It's messy. It's not as clear cut. It's not like a science, but it's there for you to benefit you. And as long as you think about all the factors as it relates to your business or to you as an individual or to your art, it can really help you along the ways. So let's get into the more fun stuff, right? Different types of intellectual property for different situations. I'll be watching TV or listening to a show and someone will say, you should patent that idea. And it drives me crazy because they're not interchangeable. A patent is not a trademark, is not a copyright. There are differences amongst the three, and they are specific for what they do. So just a little bit of a background, just so people have an idea. Patents, they grant exclusive rights to an inventor to exclude others from making, using, offering for sale, or selling the invention throughout the United States. So when you hear patent, think invention. They also have plant patents, which I always find entertaining, as far as breeding of plants and all that kinds of stuff. Patents are not indefinite. They usually only last, I think it's 15 or 20 years. I think it's 20 years. So for example, if there's a generic drug that you see, that means the patent probably expired or there was a contract to allow the generic maker of the product to continue. Trademarks. Now, trademarks, you're not going to necessarily deal with on a direct basis unless maybe you're a graphic designer or you do regular work for commercial customers. But trademarks protect words, names, symbols, sounds, or colors that distinguish goods and services from those manufacturers sold by others. And this is the important part, that indicate the source of the good. So a trademark is your brand, basically. So Nike's Just Do It, that's a trademark, right? That's like a slogan that you hear it, you think of Nike. Same thing with the swoosh symbol. As long as you're using a trademark, you can extend it indefinitely. So artists can potentially obtain a trademark if they do their art under a brand name, or maybe they have a specific style or logo they want to utilize. I use Banksy as an example. His name is trademarked. It's managed by, I forget the name of the company, but there's an official Banksy company that you can go with to authenticate his works, and they've trademarked his name. Copyrights, and I'm going to go into a little bit more detail, but just to give you a basic understanding, they protect works of authorship. That's what we call the term of art in law, right? There's a specific definition for that. It protects works of authorships, writings, music, works of art that have been tangibly expressed. They last for the life of the author plus 70 years, and they don't need to be registered. So if you create a work of art, you have copyrights in it immediately. But there are benefits to registering the copyright with the federal agency, and we'll get into that in a little bit later. Candy, you were raising your hand. Do you have a question?
It was specifically about copyright, but you're going to get into it. So I'm going to wait, and then I'll see if you answer it.
Okay, sounds good. And then everyone, feel free to chime in. If you have questions, just type them into the chat, and Candy can read them to me. So just the background of copyrights, it goes all the way back to the Constitution. This idea is not a new idea. Article 1, Section 8 talks about granting Congress the ability to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. So this is the patent and copyright clause. So even a couple hundred years ago, there was incentive for creatives to make work and to put it out into the world, because the founding fathers thought that benefited society to get these ideas out there. So they wanted to create an economic incentive for people. Initially, it was just for books and maps. It's changed a bunch of times over the years. The most recent major update to the Copyright Act, as far as like the big body of the legislative language, was in 1976. But there have been several amendments since then. So what can be copyrighted? What does a copyright cover? The quoted definition is original works of authorship, there's that word again, fixed in any tangible medium of expression now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of machine or device. So it's a lot of words, but basically it's you have an idea and then you put it into a tangible medium. So think of a block of clay, and then you turn it into a little pinch pot or sculpture or whatever. That's a tangible expression of the work. And that would be the copyright. right? That's the item with which you have copyrights vested in it. However, as we'll get into in just a little bit, the physical work is separate from the copyrights, and you can sever the two. They don't always travel together. So there are 8 categories of what can be copyrighted. I list them for you here, but it's literary works, musical works, including the words, dramatic works, including the music, pantomimes and choreographs, so maybe dancing, pictorial, graphic, sculptural works. That's the one we're mostly interested in, the visual art, motion pictures and other AV works, sound recordings, and architecture. As we mentioned earlier, I want to reiterate this. It's extremely important. Copyrights protect the work, and its unique expression, but not an idea. It's not the idea that's protected. Because if the idea was protected, then what you could do as an artist gets more and more limited over time. So that's the compromise. You can have rights to the specific tangible medium, like a work of art, or but you can't take the idea, right? I did some research after I started drawing spirals, and I guess I think maybe it was Louise Bourgeois. I don't remember. There was an artist, Leonora Carrington, someone who put a lot of spirals in their work, right? So if she had a copyright on that, I could never make spirals. You can never put spirals in a work. So unique expression is what's protected. And as we're going to talk about, it's widely open to interpretation as to what's a unique expression versus a copyright infringement. So ownership of copyright, as I said earlier, you don't have to file anything. You make a work, you have copyright rights in it immediately. If there are multiple authors of a work, so if you work on something with somebody else, then they are the co-owners of the copyright. If there's 2 of you, it's 50-50, 3 of you, 30-30, things of that nature. Something that we're not going to go into detail today, that if you need another presentation on in the future, we can always talk about, but works made for hire. You may have heard that phrase before, again, particularly if you're in the graphic design area. But this changes the general nature of a copyright and who owns it. So as I said earlier, if you're the author and you make the painting or you make the design, you have the copyright. Under a work made for hire, the employer would own the copyright immediately. So in the case of a work made for hire, the employer or other person for whom the work was prepared and is considered the author for purposes of this title, and unless the parties have otherwise agreed, and a separate written instrument owns all the copyrights. And again, we're not going to go into the details of what constitutes a work made for hire. A lot of times the work won't technically qualify under the statute. So you'll see in agreements, even if it's not considered a work made for hire, the artist still transfers all rights to the work to the employer or to the client, whoever it may be. So that's something to just keep in the back of your mind. The copyrights, the actual intangible parts of the property, they can be bought, sold, bequeathed. It's property. It's just intangible. It's not a real object. The classic example is a bundle of sticks, and you can give out different sticks from the bundle and keep the other ones, or you can give away the whole bundle. Since we're dealing with visual art, why don't we say it's a pack of paintbrushes, right? Each brush is a little bit different. Each one corresponds to a different right, and you can take them out of the package or put them back in the package.
Josh, there's a question. So can a work for hire situation exist where no money is exchanged? And would you still write up a contract? Is an email agreement enough?
Okay, so I'm going to give you every lawyer's favorite answer. It depends. It's really hard to answer hypotheticals that are that detailed, but just a little bit of a background. If you're an employee working for a company and part of your job, or you're using the computers at their workspace, they're going to probably own the work, especially if you do it during work hours. Even if it's for your own personal thing, they probably own it. If it's a contract with a client, I would always recommend in writing and not email contracts. And I'll tell you why. Not every contract has to be in writing. You can have oral contracts. Oral contracts are enforceable. However, having the writing makes it A, more formal, and B, will avoid issues of enforcement. So certain contracts have to be in writing. An example, it's called the statute of frauds. We're not going to get into that. It's a legal concept. But for example, if the work can't be completed within a year, it needs to be in writing. If you're exchanging real property, which is not art, it's real estate, then it needs to be in writing. There are other examples of that as well. So just to avoid any sort of miscommunication or anything like that, I would recommend, generally speaking, having a written contract. And if you're providing a work to a client, then you should have the discussion of who owns the copyrights. Is it a work made for hire? Are you transferring them all of the rights? Are you just transferring them the ability to use the work, right? Are they getting a license for it? These are very nuanced, specific ideas, and that's where the value comes in. Licensing the work to somebody will be cheaper than selling them the work, right? Because if you license it, you can also always license it to someone else. You have more value that you as the artist can get out of it. If you sell the work, that's it. They own it. They can do whatever they want with it. And that is your one fee. So I hope that answers your question, but it does generally depend. Basic rule of thumb is, if you can, get a written contract. I think that's the best way to do it. Make sure it's signed too. You both sign it. So duration of copyright. As we discussed earlier, it's changed a lot. It's 70 years after the death of the last surviving author. So if it's a group effort, someone dies at 50, someone dies at 70, it's 70 years past the person who died at 70, assuming they were the same age. If it's a work made for hire, an anonymous work, or pseudonymous work, then it's 95 years from the date of first publication, which is basically where it's out in the world, or it's 120 years from creation, whichever expires first. So I don't have any case dealing with an argument over how long a copyright has lasted if it's anonymous work. But just to give you an idea, 120 years after creation, well, how do you prove when it was created? What if, maybe I have evidence that the year on the artwork is wrong. So even little things like that you wouldn't think would be a big fighting point could potentially cause litigation problems in the future. So just to point out how there's these little inconsistencies and different interpretations of what it could be. So these are the general guidelines for the duration of, yes. Mm-hmm.
So it says 1978, right?
That was when that time frame became effective, correct.
And before that time frame, let's say for an artist that was creating, I don't know, in the 1910s, do you still have to wait a certain amount of years after they have passed to be able to, I don't know, paint their work?
Yes, you do.
Okay.
And I don't have it here, but within the statute, it talks about works that were made under previous laws, right? And how long they could be extended for. If it's the 1910 and it's a public work, I don't have it in front of me, so don't quote me. You're probably good at this point. But at the same time, there is a specific timeline within the copyright legislation, depending on when the work was made. And there were a good amount of amendments between the early 20th century, then like the 70s. There was a couple amendments. So there's several categories of what it could fall under. And just so everyone's aware, the US government, they might need to improve some things, but when it comes to the IP side, their websites have a lot of very useful information. They try to make it very user-friendly. So for example, for copyrights, they have something called the copyright circulars, and they're just detailed explanations of how certain things work within copyright. I would certainly encourage anyone, if they're questioning it on their own, just to look into that as well. It's usually, if they're not going to call a lawyer, if they don't want to do that, at least to get a general idea. It's not legal, from the government's perspective, they're not telling you for sure, but at least you can get an understanding of how it works. So I mentioned earlier, the ownership of a copyright is different from the physical object, right? That's the physical object. The copyrights are different. This is in the statute, 17 U.S.C. 202. The specific language is transfer of ownership of any material object, including the copy or a phono record, so a CD, in which the work is first fixed, does not of itself convey any rights to the copyright embodied in the object, nor in the absence of an agreement does a transfer or ownership of a copyright or any of the exclusive rights under a copyright convey. So if you're an artist and you sell a painting to a collector, they're not buying the copyrights from you unless your contract says, I'm giving you the copyrights under this work, period. They are only purchasing the physical item. Now, they can do with that physical item as they please. You can't really tell them what to do with it. I mean, there are agreements where you can sort of limit it, and if the parties agree to it and it's not fought in court, then you can do that. But oftentimes you're not permitted to control how they affect what they do with the work, unless it affects your moral rights. more recently in the US, artists do have moral rights under VARA, which is the Visual Artists' Rights Act, 106A under this section. We could go into that in a different day, but there are moral rights to be aware of. So attribution, things of that nature. So what are these rights that I keep talking about that you can have when you create a work? You can reproduce the copyrighted work in copies or phonographs. I've included the definition of copies and phonographs. I'm not going to go over that, but it's pretty self-explanatory. If you make the work, you can reproduce it as many times as you want. You know, if it's a lithograph and you want to print 100, print 100. You want to print 150, print 150. It's up to you. You can prepare derivative works based on copyrights. This is where I think also can cause a lot of value for artists. A derivative work, I think a good example personally, you know, they talk about a movie version of a book is like a classic example of a derivative book, or a derivative work, I should say. The original art is the book, and then they make a movie, which is a separate copyright. However, think of it like this. If you have an image you want to put on a shirt, you have the right to put it on a shirt. You want to put on a hat, you can put on a hat. That's your right to prepare derivative works based on the copyright. Maybe you want to do a series of the works. So another artist doesn't have the right to take your similar or, you know, substantially similar idea and do a series based on it without, you know, unless it's fair use, unless there's an exception, but you would have that right. And when it comes to derivative works, you know, you can sell, when you sell your IP or you license your IP, you want to maintain, generally speaking, your rights to the derivative works unless you're being paid for it. In my personal opinion, now, every situation is different. Every contract is different. Every party has different needs. So it's a very case-by-case situation, but you can get a lot of value out of the derivative aspects of works. I think personally, especially as we continue in the future, easier to make your own t-shirts, easier to make your own logos, your own posters at home and sell it. So if you want to keep those rights, you can maybe get some value out of that. You can distribute the copies. Yes.
Just a quick question. I'm thinking about the derivative works, and what about like fan fiction or people who are really inspired? I think about the Obama,
Yes,
the image that everyone started making their own versions of his campaign image, you know, and I can't imagine everybody went and got permission. Like, how does all that work?
right. So the Shepard, that's the Shepard Fairey case, the Obama Hope poster. They ultimately settled. He got sued, I believe, and the big question was who owns the photo, right? And then who was able, so who gets the benefit of the stylized version of the real photograph? As you mentioned, not all fan fiction writers are getting permission, but you are permitted somewhat of the ability to create fan fiction or make your own work with it, simply because, as I mentioned earlier, Marvel can't sue everybody. They can't go after every single person. Even if they did, the court would look at it and say, well, what damage to your brand was done? Most people probably, if you see a fan fiction work, aren't going to assume that it was released by Marvel, as an example. So you can be safe. I don't want to say safe. Like, there are examples of companies being overzealous. Disney's notorious for going after people, actually, when it comes to certain trademarks and copyrights in overly litigious ways. But as you said, with using that photo, yes, not everyone got sued, but Shepard Fairey or whoever made the image got sued because they were making money off of it, and they were making posters, and so they were creating derivative off of derivative, and they were benefiting from it. So there's damages there that could be gotten by the original owner of the photo, and that's where the lawsuit originated. Did that answer your question?
Yes, thank you.
No problem. Yeah, it can get a little complicated, right? I mean, I've spoken to people about this before, and where they've said to me, hey, you know, I'm making this version of an image. And I said, well, you know, technically that's probably copyright infringement. You know, either you might want to, you know, and you probably can't get your own copyright on it. And they were like, well, I'm going to do it anyway. It's whatever, you know, it is what it is. So, you know, that's that decision making I was talking about before. It's always your choice how you want to proceed. So generally, with copyright notices, people have a conception that you need to register your works to get a copyright. As I said before, that's not true, but it's really important if you're going to sue someone for copyright infringement. So the timing of the registration is important as well. Under the Copyright Act, you're entitled to attorney's fees and to statutory damages, I think up to $150,000 if you prove your case. That's a big incentive for two reasons. A lot of times damages, which is the amount of money you would receive if you win a lawsuit, is difficult to calculate, particularly if you're a lesser known artist and you're unsure of how much money you would have made off the work that was copied. So if you have the statutory damages that you can point to, it makes it easier to recover some funds. And additionally, the attorney's fees provision will give incentive to lawyers to take your case. So unfortunately, being a lawyer, it is a business. We do some pro bono or free work for needy causes, but generally speaking, lawyers need to get paid. So if you're suing someone and you don't have a lot of money to hire an attorney, being able to point to the attorney's fees provision, if you win, may encourage a lawyer to take the case. So as far as the registration is concerned, generally speaking, you need to register within 3 months of when you first publish the work. So when you first make the work public for people to see, register within 3 months or 1 month after you've learned of the infringement, right? So you see someone has infringed your work, you found out within 30 days, you got to try to get it registered or file the registration at a minimum. Additionally, that's just to get the attorney's fees or the statutory damages. You can still sue even if you don't register within that timeline. You're just not entitled to that. But you do need to register prior to filing suit as well, right? So there's two prongs there. So you
Sorry.
No, you're good. So you need to have registration to sue, and you need to have registration within that specified time frame to be entitled to the statutory damages. So now we're going to get to the fun stuff. Fair use. It is codified, meaning it is in actual writing. It's in statute, which basically says, yes, I see a question.
Sorry, yeah, there's another question. How would registering the artwork work with emerging artists? Would someone who is just starting to create larger, serious pieces have to register the works as they've made it, or would waiting until you have a large amount of work better to register?
Again, so this is sort of a personal preference sort of thing. So the statute is the statute. If you want those certain protections, it's better to file within 3 months. It can get a little onerous, but you can hire attorneys or organizations and pay a small fee to have them register it for you. You provide them certain information, they can do it for you. As a lawyer, I'm always going to recommend registering your work, but I'm also an amateur artist. I understand that if you put out 500 pieces because they're small scale, you're not necessarily going to register all 500. It's a lot of work. So it's a case-by-case scenario how you want to manage your own work. If you want the ability to get the benefit of the statutory provisions that give you the attorney's fees, then you're going to want to register within those 3 months, and you're going to want to have a procedure in place to do so. If you want to wait to do it as a big block, that's fine too. It's sort of a personal preference sort of thing, but as a lawyer, I'm always going to recommend following the statute. I'm always going to recommend registration. But I do understand, practically speaking, it's not necessarily something you can just spend all your time doing.
How much does it cost to register a work?
I don't have in front of me the exact fee. It's a couple $100, maybe a little less. It's not too onerous. They don't want to make it too expensive. And if you want, towards the end, I can actually look it up on my computer and tell you the exact fee at the end. Yes, good on the question. Any other questions? Okay. So in the statute, it states the fair use of a copyrighted work includes any use by reproduction in copies or phonorecords or by any other means specified by that section for purposes such as criticism, comment, news, reporting, teaching, scholarship, or research. That's not infringement, just as a matter of law. The issue becomes, how do you prove that it's fair use? Well, there are statutory factors. In the law, factors are the framework for which a court will analyze a particular factual situation. So they'll use it as sort of a filter to analyze the facts and make a determination as to whether or not they think something's fair use. So the factors are this: the purpose and character of the use, including whether it's for commercial or nonprofit. So if you're making something that could be infringing, and it's for a nonprofit purpose, you're not making money on it, that points to it being fair use. But just because you charge for it doesn't mean it isn't fair use either, right? It's not a dispositive factor, and it's not a yes or no. It's a balancing of the facts. But the court takes that into consideration. They take into consideration the nature of the work. So what was the nature of the original work? Was it a sculpture? What's the new one? Is it an art movie? You know, if it's a movie, that's a big difference. Is it going to be clear that it's infringing on the original work? The amount and substantiality of the portion. So how much of the work was utilized? And then this is sort of what many people think is the most important factor. What's the effect on the market or the value of the work? So if someone infringes on your work, they're saying it's fair use. If it's not going to affect the underlying market, that points to fair use, because it shows that you're not trying to swoop in on the heels of the artists who did all this work to get there in the first place, right? So we're about to see a case where it was not considered fair use. Very famous artist, is a very famous case, Rogers versus Coons, and I included a picture. On the left-hand side, we have the original photo, which was taken by a professional photographer. He had had his work shown in certain museums. He had sold a certain number of works. He had had 5,000 copies of this as a card made. So he was a professional, right? It wasn't just an amateur's work. Jeff Koons saw it in a store one day, bought the card, ripped off the copyright notice. Now, I didn't go into copyright notices. You're not required to do so, but if you want to put people on notice that you're claiming your copyright, you can do that. He ripped that off. He sent it to his workers, and he said, make this as a sculpture. And the case talks about, actually, there was what's called discovery, which is the evidence. There were texts, there were messages, there were letters, there were memos where he's saying to his makers, it needs to be more like the photo, you know, make sure it's realistic, these kinds of statements. And as you can see from the photo, it's an almost identical copy of the image. Now, maybe the colors are a little bit different. The faces are maybe slightly more cartoonish or surreal, maybe, to kind of point to the banality of it, right? This was for the banality show. And what he testified as to was that, do I have the quote here? Let's see if I don't have the quote. I don't have the quote here, but the whole purpose of the artwork was to demonstrate the commercial side of America and how America's gone into a very cookie cutter, generic direction. So that's what he was commenting on. But the physical work itself, as you can see, it's almost identical. So the lower court ruled in favor of the photographer, and the appellate court, that higher level court in the federal circuit, agreed. So what is copyright infringement? The factor, right, what they consider, what the court considers, is the plaintiff must show that they own the copyright and that the defendant copied the material without authorization. So that's why you have to register your copyright prior to the lawsuit. That's prima facie evidence that you have a copyright on that work. That's why the court requires it. The court here found that the plaintiff owned the copyright. And they also found on summary judgment, meaning there wasn't a jury trial. They had an argument in front of the judge, and the judge decided there's no argument here. This is what it is. They found that the works were so substantially similar, reasonable jurors could not defer on this issue. Now, what that means is, even if it went to a jury, no reasonable jury would say that these works are not identical or almost identical, to the point of now we need to decide if fair use was in play here, right? So that's the first step of the process. Do you own the copyright? Was it copied? And then, was it copied is oftentimes a question for the jury. In this case, it wasn't a question for the jury because it was so obvious. And the typical question of the jury for copyright infringement is whether an average lay person observed would recognize the alleged copy as having been appropriated from the copyrighted work. So that's very broad. Would a regular person on the street look at the two images and say, yeah, that one copied from that one? That's basically what the question is to the jury. It was kind of funny. In the case, Koons was saying, well, I didn't use this, I didn't do that, I didn't copy this part. And the judge made it a point to say no copier may defend the act of plagiarism by pointing out what they didn't copy, right? You can't say, well, I didn't copy this percentage of it. It's a fact-based criticism. Oh, here is the Kuhn's quote I was making before. So he was saying it's a fair social criticism and asserts support for the proposition that he belongs to the school of American artists who believe that mass production of commodities and media images has caused a deterioration in the quality of society, and that this artistic tradition of which he is a member proposes, through incorporating these images into works of art, to comment critically on both the object itself and the system that created it. So I want to highlight the criticism of the object itself, because the court notes that that's important. So we can go through the analysis very, very quickly here, but those 4 factors: the purpose and character of the use. This was for a commercial use, so it was clearly for a commercial purpose. Kuhn's was making money off this work. He can say it was satire, but overall it was for a commercial purpose. So they found that yes.
Just for the sake of time, because I know that some students need to go off to their classes, but if you guys want to stay, I think you have one more case study.
Just one more case. In that case, will probably be a little bit quicker.
Yeah, which is an interesting case study. So if you can stay. If you have to leave, I understand. If you have more questions, you can always direct them to me. I'll put my email in the chat for everyone. And I just wanted to say that. So thank you, Josh.
Thank you. Yeah, I apologize. I'm a little long-winded. I am a lawyer, right? We do like to hear ourselves talk sometimes. So I won't go through all 4 factors, but the long and short of it is here, they found that he copied the work. They didn't think it was for fair use. The quote that they used was, the amount copied exceeded the level permitted for fair use. He copied it basically entirely. Additionally, I don't have it here, but something that they talked about is Kuhn's argument of what he was trying to accomplish with the work was based on society at large, right? He was parodying American consumerism. He wasn't parodying the image. He wasn't making fun of the image or commenting on the image. He co-opted that image for his art. So I don't know that would have swung the case the other direction if he was, satirizing the actual picture itself versus society. But that's a major thing to consider here. If you're utilizing a prior work to make a point, you should probably be making that point about the work versus society at large. But again, you're not always going to get sued. It's always a case-by-case thing. So I'll be real quick. The Carew versus Prince case, this is very, very interesting. Richard Prince, it calls himself an appropriation artist. He takes other people's work. That's what he does. But he does it for a purpose. So this case was about a book called, I think it was called Rasta or Rasta Man or something like that. A guy lived in Jamaica for many years with Rastafarians. He took a lot of pictures of them. Prince took the images and he distorted them in different ways. I put an image here of one. I just like this picture. I like the guitar. It's very cool to me. So this was one of the images. There were 30 pictures at issue in this lawsuit. And it's pretty interesting. He took these photos and just drew on top of them, right? Or distorted them or added filters to them. And yet the court found, without going to a jury, that 25 of the 30 works did not infringe. They thought that it was transformative enough to create a new work entirely. This is one of the images that they were less sure of, right? They weren't so sure with that one. So the big, a quote here that I think is important. I mentioned the transformative aspect of it, right? Whether the new work merely supersedes the object of the original or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. Whether the work is transformative. Transformative work lies at the heart of fair use. So with Prince, the fact that his work, and you don't see most of the pictures, but the fact that the majority of them were heavily distorted and you couldn't tell anyway, and that he was trying to say something new was a major factor. Another major factor is while the original artist had sold the book, he didn't make a whole lot of money. It wasn't super widely distributed. So not a lot of people had known about the work. So it wasn't considered, they didn't consider that he was co-opting the guy's market, right? These Prince artworks were separate from the market of a Rastafarian picture book, so to speak. Again, I put the analysis of the court in regards to the 4 factors, but that's it for the case. Yes.
Can that be said for the Obama poster as well? Because, okay, you're taking the photograph from the photographer, but he altered it and abstracted it in a way where you couldn't, well, I guess you can tell it's still the original photo, but there was a lot more work that was put into that image. But because it was for sale, I'm assuming that was where the issue lied.
Well, yeah. So usually if it's for sale, that's going to cause an issue because that means the original artist is losing out on money that someone else is making off their work, right? That's why they want to sue them in the first place. My personal take on it, now that case settled, so we don't know how it would have played out in court. I think they would have been in trouble, the artist. The photo is pretty much identical. Yeah, he abstracted it. You know, he added the geometric shapes and the polygons and the different layers of color, and he added hope on top of it.
Right.
So that's where that argument would be. But at the same time, it's a pretty much identical image of the photo. So then the question in my mind would have been, was it a derivative work? And
right.
If it was a derivative work and not fair use, then it would have been infringement. So there would have been two questions there. A, is it derivative or is it its own piece? And then B, is it fair use? And then within fair use, is it satire? Did it transform it? Those are questions that the jury or the judge, if it's a judge case, would consider.
I have another question.
Yes.
Someone says, say if I make a website portfolio and I post my original work, would I need to copyright or watermark each piece? And how would I go about this process?
There are products that sell. I'm just trying to look up how much it costs to the exact cost of copywriting or registering your copyright. But there are products you can utilize to create watermarks. A copyright notice, again, as a lawyer, I'm always going to recommend that you do it because it puts people on notice that you're cognizant of your rights and you want to protect your rights. The watermark does help, particularly if you're a photo artist, right, or a digital artist. It's a lot easier to do a watermark on a photo than it is on maybe a painting.
Right.
You can also put a copyright notice on the backside of a canvas or whatever object you do your work on. I'm always going to recommend it, but it's not necessary as far as creating the copyrights. You get the rights as soon as the work is created.
The copyright notice that you're talking about, it's the C with the circle?
That's part of it, yeah. And then the year that the work was created.
Got it, okay.
As well as your name or whoever's claiming the copyright. But yes, that's the little C is part of the copyright notice. Mm-hmm. And I'm free to listen to other questions. Don't think I'm rude. I just want to get you guys that information.
I think part of the judgment against Ferry in that case was based on his active lying about the source he used as well.
There was no judgment. They settled. There was no judgment that I'm aware of. Copyright fees, registration. Okay, yeah. So depending on, there's a whole bunch of different fees. Registration for a basic registration of a single author is $45 if it's electronic. So they've cut it cheaper, and it's $125 for paper filings. Then they have other costs as well for updates or revisions of a database. It's $500. So if you go on the copyright database, it'll have all the fees depending on what you're trying to do. It's a couple $100 depending on what you're trying to accomplish, though.
Can you put that link in the chat for everyone? Sure. So they can... Anyone else have any questions? Oh, yeah, no. Thank you so much, Josh. That was super informative. I will be sending out this copyright guideline to my students and those that have registered for the talk. Thank you guys so much for participating. And if you don't have any more questions, you're off to next
having me. My email is in the outline. If you have any questions or want to reach out to me after the fact, please feel free. I'm always interested. If you guys want to learn more, there's a bunch of other stuff about copyrights and other cases we can talk about. So if you're interested, let your school know, and I can always come back. I love doing it.
Thank you so much.
Thank you, guys.
Appreciate it.
Absolutely.
Thank
Let me
you.
get that link to you now. Thank you so much.
Thank you.